Now, when we're talking about these votes and these opinions, there's several sort of ways to think about how justices make their decisions, how they decide how to vote, and what they write in their opinions. The most common way things are described and what you would read about in law school is what's known as the legal model. What the legal model says that justices should interpret the plain meaning of the law and the intent of the person who wrote the law, right? And apply it. Just apply the plain meaning and the intent. And they should also follow stare decisis. Stare decisis is, again, just some Latin here that really just refers to precedent, that they should follow previous court rulings. And it's clear that people think this is really important because in these amicus briefs, the oral arguments, in the conference meetings, and their opinion writings, all over the place, they're talking about, as we've seen in these other cases, these appeals to precedent, these appeals to stare decisis. Okay? And so people think that that's really important. But it's not clear that when the justices are making decisions that they're actually following this logic. In the lower courts, the legal model works fairly well. Okay? But when you get to the Supreme Court, it doesn't quite work as well, in part because precedent can exist on both sides. If I want one side to win, I will then decide that I want that side to win and then find the previous cases that suggest that side should win. Find some logic that suggests that side should win. If I want the other side to win, I'll just find a bunch of different cases. Also, if we just start with the idea that you should interpret the plain meaning of the law, well, laws have vague meanings. It's not always clear what they mean. You know, when they talk about sort of you should have equal pay for equal work, what does it mean, equal work? And when you talk about the intent of the law, just interpret the law as it was intended. Well, whose intent, right? Maybe the person wrote the law, and then Congress passed the law, but maybe when it was voted on, Congress thought they were passing it for one reason, and the person who wrote the law wrote it for another reason, and then maybe the president signed the law and hoped for something else. And then let's also remember, members of the judiciary are appointed for life. Members of the Supreme Court can't go anywhere else. They've reached the pinnacle of their profession. And so they can decide how they want, and they will face no punishment at all. So they can do what they want. It's possible that what happens here a bit is that precedent acts as a constraint. That is, justices will tend to rule on cases in ways that are consistent with previous rulings because it seems as this is more fair. And so unless it's a major case that's really important to them, they'll say, all right, I'm not going to rock the boat so much. Because ultimately judges want people to agree with the way they rule. There's a famous line about the Supreme Court that the justices have neither the sword nor the purse. What that means is that the president wants something done, or the president wants some policies, they have the military. If Congress wants things done, they can fund things or they can refuse to fund things. The judges make a ruling, and that's the end. They can't enforce the ruling. Other people enforce the ruling. And so people have to agree with the rulings. And so at least through the argument of precedent, they can say, hey, we're just following the way things have been, and you should agree with this. When we talk about votes on the merits, one of the best sort of explanatory powers is the attitudinal model, right? That justices just vote based on their preferences. Liberal justices vote in a liberal way, conservative justices vote in a conservative way. And the reason for this is, as I said, they have lifetime tenure, they're not going anywhere, they lack ambition in that sense that they have reached the top job they could ever have, so who are they trying to impress? And it's the court of last resort, it's the Supreme Court. When the Supreme Court decides how a case should be decided, that's the end. There's nowhere you can go. There's no one else you can appeal to. And there's plenty of evidence that Supreme Court justices vote based on their preferences. That does not necessarily mean they write their opinions strictly based on their preferences. Right? Here's some evidence of this. What you have here is on the x-axis, justice's ideology from liberal to conservative. On the y-axis, you have the percentage of the time the justices vote in a liberal manner. And what you can see is that, as a general rule, The more conservative justices on the right, Scalia, Rehnquist as Chief Justice and just as Associate Justice, they tended to vote in a conservative manner, and Justice Marshall and Fortas and Brennan tended to vote in a liberal manner, and they were on the liberal end. We'll note, right, however, they're voting liberal about 75% of the time. The conservative justices are voting conservative about 40% of the time. So it's not like they never deviate from their ideology. But as a general rule, if you wanted to guess how they were going to vote, you would say they're going to vote the conservative way or the liberal way. Specific cases with specific facts may get them to vote in ways that seem inconsistent with their ideology, but the typical case would not. Now, the final way people think about how justices make decisions is what's known as the strategic model. The idea here is that justices want their preferences acted in law, but they're constrained because there are other actors involved. Their choices are interdependent, right? There are other justices. You need to get 5 justices to sign on to an opinion for it to be precedent-setting. So a single justice can't just say, this is how I want things to be, this should be the law. They have to convince 4 others, and that might mean they have to sort of make some compromises in their arguments. If they pass a law, Congress can pass a law. If they rule a law means a particular thing, Congress can come along and pass a new law saying that the Supreme Court was wrong in how they interpreted the congressional law. And unless it's literally unconstitutional, there's nothing the court can do about that. And then again, the public can constrain the justices because it is public opinion that we should follow the courts that gives the courts their power. Also, institutions matter here. Institutions here refer to the formal and informal rules about how the court operates, right? So if you consider, for example, the rule that the informal rule that the Chief Justice speaks first and then they go in order of seniority. If you're the most junior justice on the Supreme Court and you want your preference enacted and you think, oh, I've got this great argument, I'll write this great opinion, by the time they get to you, the other 8 justices have spoken, they might have all made up their minds and you are not in any position to influence policy, right? So the strategic model says the justices understand that they're constrained by these other people and these institutions, and so when they make their decisions, with this in mind. And when they write their opinions, they write their opinions with this in mind. And the best example of this is, again, Craig v. Boren. Justice Brennan wanted the court to decide that gender discrimination was the same thing as racial discrimination, or at least was as threatening as racial discrimination. And so they should review cases of gender discrimination with the same skepticism, with the same viewpoint as they view cases of racial discrimination. But he knew he couldn't get 4 justices to sign on to that. But he could get 4 justices to sign on to this idea that he read in the Ginsburg amicus brief, that it should be not quite as given as quite as high scrutiny as racial discrimination, but higher scrutiny than most other cases that the court considers. And that's the perfect example of the strategic model being used in a opinion on a case.